Hi everyone, a very good evening from Team Educating. Pranjal this side. I would first start the webinar by giving a short introduction of Divyanshu sir, and then sir will proceed ahead with the webinar. Advocate Divyanshu Agrawal is practicing in Supreme Court, Delhi High Court, Allahabad High Court, and other high courts, including NCLT, NCLAT, etc. He is also a fellow member of the Institute of Chartered Accountants of India. Sir has 17 years of professional experience and has work experience with professional firms of repute like EY, PwC, and Deloitte. He has also worked in the chamber of renowned counsel of Delhi High Court, senior advocate Srimati Premlata Bansalji. His experience includes rendering advice and representation in the matters of various MNCs, Indian companies, government undertakings, service providers, NPOs, etc. Sir has also represented many domestic and international clients before various forums like Honorable Supreme Court, Delhi High Court, Allahabad High Court, Nainital High Court tribunals, etc. In a few matters, the Honorable Principal Bench of NCLT has appointed him as chairperson of the meetings of shareholders of the transferee company in terms of the directions issued. Some of the clients handled in courts by Advocate Divyanshu Agrawal includes Jubilant Group, BMW Group, Crocs Inc., Vedanta Limited, etc. So this was a brief introduction of Devanshu, sir. So the whole educating team is really happy to have you on board for this webinar. Over to you, sir. You can start with the webinar now.
Hi, Pranjal. Hi. Am I audible?
Hi, sir. Yes,
Yeah.
sir, you're audible now. I was just saying that on behalf of whole educating team, I would like to thank you for presenting your webinar on our platform, and you can proceed ahead now.
Thank you so much. Thank you, Pranjal. Thank you, Arun. Thank you, educating team. Thank you. Is it visible? This slide is visible to
Yes, sir.
everybody? Okay. The topic for today is what is the significance of document identification number in income tax department communication? As all of them are every day dealing with a lot of notices and the correspondences which we receive from the income tax department. So now, considering we are into the digital era, the relevance of document identification number is very important. So the first question which comes in our mind is, what is the need of document identification number? Friends, DIN is an identification code which is attached to every communication issued by income tax authority, be it notices, any notices, 143.2, 148, or orders like 143.3, or summons, etc. Every document must be supported with a document identification number. So whenever you see a notice, on the top you'll find assessment year, PAN number, and then you'll find DIN number. Its introduction was crucial to maintain a proper audit trail of department records. So every record has a proper audit trail. Gone were the days when department issue a notice without any backup. Even the document was not recorded in the system and they issue a notice to the assessee. So now every document must be supported with a DIN. That is mandatory condition. So as part of the e-governance initiative, as everybody is aware, ITBA is Income Tax Business Application Portal, which was enabled for each PAN or taxpayer to streamline the communications and proceedings under the Income Tax Act through e-assessment scheme. So first, government has notified e-assessment scheme, later on moves to faceless assessment scheme. Now, during the digital era, it is equally important to have an efficient identification and tracking of all the communication. So every communication must be supported with a DIN number. That is the reason behind Income Tax Department introducing the DIN to have more transparency in the documentation. Now, the next question, this is the need of the DIN. Now, next question is how to implement. What is the implementation basis of the DIN? As everybody is aware, there's long time back, this DIN was introduced through Finance Number 2 Act 2009, and it became compulsory on October 1, 2010. Not properly operational at that time. So all the communication which was issued by the department were required to bear a DIN, ensuring validity and eliminating the use of manual communication. So way back in 2009, Government of India has taken an initiative to move from paper to paperless atmosphere. So initial application was extended to, so this was introduced, but its applicability was extended to July 1, 2011 to arrange infrastructure nationwide. Because number one, we all members are not very habitual of digital documentation at that time in 2009. Number two, the government doesn't even have an infrastructure to support these digital transactions. Finally, because of a lot of hassles, the same was repealed by Finance Act 2011 because of a lot of challenges and insufficient infrastructure. Just a year prior to the COVID, the CBDT issued a circular number 19/2019. This was a circular issued after when the notification of e-assessment scheme was notified. This was issued on August 14, 2019. As everybody is aware, the CBDT has a power coming from Section 119 of the Income Tax Act to time issue circulars and the notifications. So in the statute, there is no terminology called document identification number at that time. So instead, its implementation is governed by CBDT circular under the authority of Section 119 of the Act. This circular is very important. Now, question comes, what does that circular talks about? Friends, this is very important because day and day, every day, what we are vouching and we are seeing that the department is issuing notices and not complying with this circular. They are issuing notices manually. They are issuing notices without DIN number. So the question comes in our mind whether to challenge those notices or not to challenge those notices. So this is, for that, it is equally important to read the circular. What does circular number 19 talks about? According to this circular, no communication shall be issued by any income tax authority on or after 1st October 2019. Any communication issued by Income Tax Department effective from 1st October 2019 and onwards, it is mandatory to allot a computer-generated DIN and mention the same in the body of that communication, whether it be 143.2 notice, whether it be 148 notice, whether it be 142.1 notice. Every communication must be supported with a document identification number. Now, question comes, what in case if the document is not supported with DIN? So any communication being notice, order, or any other correspondence issued without DIN shall be rendered as invalid and shall be deemed to have never been issued. Let us see what does the circular talks about. Now the question comes, is there any exceptional circumstances in this circular, or is it mandatory that every document must be supported with a DIN? Yes, there are certain exceptional circumstances. Let us see what are those exceptional circumstances. The aforementioned CBDT circular does outline certain exceptional circumstances where the Income Tax Department can issue without quoting DIN as stated below. These are the certain exceptional circumstances. So in case if the Income Tax Department is following these routes and if it is covered with these exceptional circumstances, so these are the safeguards which is given in the circular. Number one, technical difficulty in generating or allotting or quoting DIN. So in case if the department is facing any problem in generating, allotting or quoting DIN, then yes, they can issue a manual notice without DIN. Number two, Income Tax Authority while discharging an official duty office. Something is very urgent. They need to issue a summon or something, but they are not in the office. So it is difficult for them to generate the DIN. In that situation, yes, they can issue a notice without DIN. Third, delay in PAN migration, and PAN is with non-jurisdictional AO. Section 127 case transferred from one jurisdiction to another jurisdiction, and the file is with the non-jurisdictional AO instead of jurisdictional AO. In that situation also, yes, they can issue a notice without DIN number. PAN of the assessee is not available. Non-filers, no PAN applied, huge real estate transaction. They wanted to issue some notice. In that situation, obviously, because they don't have the PAN, in this situation also, this is also one of the exceptional situation. And functionality issue communication not available in the system. So in their system, the software problem in functionality is there in that system of the department. These are certain exceptional circumstances, 1, 2, 3, 4, and 5, wherein department can take the shelter in these exceptional circumstances and can issue notice without quoting a DIN. Now, the question comes, is it not, Mr. Agarwal, is it not a weapon given in the hands of the department? They can anytime can take the shelter under these 5 categories, any of the limbs they can take the shelter and can issue a notice. Is it not a discretionary power, huge weapon given in the hands of the taxpayers? No. Circular also gives the procedure. So in case if the department wanted to take the shelter under these exceptional circumstances, then they are supposed to follow certain procedure for issuing communication without DIN in such circumstances. So criteria, if they wanted to take the shelter, they need to follow these procedures. And these are the checks and balances which is given in the circular. What are those procedures? Let us see. The aforesaid exceptions for issuing manual communication without quoting DIN are subject to certain mandatory conditions to be met as listed below. What are those things? Reason for such issuance has been recorded in writing. It is mandatory to have a reason recorded in writing in advance before issuing any notice manually without DIN. And not or. And that means parallelly this condition has also to be satisfied. Prior approval from CCIT or DGIT has been obtained. And again, not or, and the communication issued manually without DIN must state, if they are issuing a notices, they must state the fact of issuing communication without DIN in that notice, date of approval from CCIT or DGIT, and specific exemption leading to the issuance without quoting DIN in the prescribed format. So friends, what is important? Whenever you receive any notice, in my last presentation at the time of discussion about reassessment proceeding, I have discussed with everybody, please do see the notice properly, whether everything is there or not, compliance is there or not. And I have discussed in that presentation to see the DIN number, whether DIN number is not. In case if you find that the DIN number is not quoted in the notice, then you need to see whether these conditions are mentioned or not, whether they have the notice that this communication they have issued without DIN, whether they have mentioned that they have taken an approval from CCIT, DGIT, and there is a specific exemption leading to the issuance without quoting DIN in the prescribed format. You need to see, in case if you find that these conditions are met, then yes, you can anytime can ask for the date of approval copy also. When the copy of the approval, you can request them and ask for the reasons also. Please provide me a reasons for issuance. Number 1, in case if they have not provided. Number 2, please request them to give them a prior approval or CCIT, DGIT. This is important. In case if they are taking the shelter under those provisions without complying with these procedures, yes, as per the circular first slide which we have discussed, the notice become non-est, invalid. Now, after following these procedures, the department take an example. This is one situation which we have discussed. They have not complied with these procedures. Then what is the next course of action? We'll discuss in later on. Now, what about the situation when in case if they are following these conditions, then how they regularize their activity coming from manual to digital? Then they are supposed to upload manual communication on the system within 15 working days of its issuance. It is not there. If they are outside the office, take an example. One of the condition is, what are the criterias? Technical difficulty. Obviously, if there is a technical difficulty, then if you are following these procedures, so then within 15 days, you are supposed to upload the proper documented, proper notice with DIN number. If you are outside office, obviously you will come next day. So this is important that you upload manual communication on the system within 15 working days of its issuance. Number 2, and compulsory generation of DIN on the systems, and communicating the DIN to the assessee as per electronically generated proforma available on the system. When manual communication is issued on account of non-availability of the functionality in the system to issue such communication, which we discussed in Lim 5, which is a clause 5, an intimation shall be sent to principal DGIT within 7 days from the date of issue of such manual communication. So friends, you see, there are a lot of checks and balances which is given in this circular. Number 1, no DIN, without DIN notice is issued, invalid or non-est. But there are certain criteria given wherein the department can take the shelters. But for taking the shelter, it is not a weapon given in the hands of the department. They are supposed to follow certain procedures. Your responsibility as a taxpayer is to see whether the notice is issued without DIN or with DIN. In case if it is issued with DIN, it is okay. But in case if it is issued without DIN, then you need to see whether the procedures has been complied by that or not. If they have complied with the procedures, then you see whether they have regularized that process in between. Because even if you wanted to challenge those notices, you see as per the regularization procedure, 15 days time is given. You need to see all those things, whether the department is complying with that or not. If the department is not complying, then comes the point wherein you need to decide whether you wanted to challenge this notice or order, or you don't want to challenge this notice or order. Now, questions comes. After reading, after understanding circular number 19/2019, after seeing what are the criterias, what are the shelters, what are the procedures, regularization, certain questions comes in our mind. What is those questions? What is the validity of communication issued without DIN in contravention of the aforesaid CBDT circular? As you are aware that this CBDT circular is issued in compliance with, and the power is given through section 119 of the Income Tax Act to the CBDT. Certain questions comes in our mind. First question, validity of assessment order. What is this validity of reassessment order or assessment order or best judgment assessment order? What is the validity of notice issued? 143(2) or 148? What is the validity? Without, in case of the DIN is not there. DIN is not there and the procedure has not been complied by the department. No regularization is there. First question. Second question, what comes in our mind? What if an assessing officer not adhered to the instruction laid out by the CBDT in the circular? So certain instructions are there. If they are not complying, they need to follow these procedures. What if they have not followed those? Third question, is it acceptable to communicate the generated DIN through a supplementary letter or intimation, or must be communicated, must it be quoted on the body of the relevant notice or order? So whether it is mandatory to have those DIN numbers in a notice itself or order itself, or through supplementary notice I can issue and I can share the DIN number. Like I'm uploading an order, simultaneously I have uploaded the intimation order by saying that this order is uploaded with this documentation number. Is it correct or not? Next question which comes in our mind, what if manual order without DIN is regularized by generating DIN after 15 days? Threshold is 15 days. What happens if it is done after 15 days? Next question, what impact would it have on proceedings if the relevant notices such as 148 and 143(2) of that did not include a mention of DIN? These are the certain questions. Many more questions are coming in the mind of our members. This is certain questions which is quickly coming in my mind, how to handle those situations. Now, friends, very important, certain judicial decision I'm going to discuss with you, which helps you in understanding this subject in a better manner. I being fortunate that I being part of this matter, which is the first High Court judgment on the DIN. Honorable Delhi High Court pronounced a decision in the case of Brandex Mauritius Limited. This was uploaded in the month of April. But friends, I just wanted to, before coming to this point, I wanted to take, after the Delhi High Court, I wanted to take, this is a favorable decision in favor of assessee, but we have another judgment, which is Allahabad High Court judgment, which is against, which is in favor of revenue. I wanted to explain you, everybody, High Court has two jurisdictional powers. One, appellate jurisdiction, another writ jurisdiction. Appellate jurisdiction comes under section 260A of the Income Tax Act. That means assessment order, CIT appeal, oblique DRP. Against that, you come to ITAT. Against ITAT, you comes to High Court. That is an appellate jurisdiction. Another is a writ jurisdiction, which powers comes under Article 226 of the Constitution of India. So writ jurisdiction, if I talk about in a tax matters, there are a lot of certain criteria wherein you can invoke and you can knock the door of the Honorable High Court in a writ jurisdiction. But in case of tax, usually the two criteria which we see are when there is a jurisdiction issue, and number two, when there is a violation of principle of natural justice. Now, question comes, DIN is a jurisdictional issue or not? Let us see what does this Honorable Delhi High Court in the case of Brandex talks about. Case wherein the assessment order was passed on 15th October 2019, but did not bear DIN. So friends, see, this circular says any communication notice order issued on or after 1st October 2019. My case falls into this. My order was passed on 15th October 2019, assessment order. So my case, this circular triggers. The said order did not contain any reason for the same, nor any approval of the specified authority as required in para 3 of CBDT circular. Now, this is a department appeal, friends. We have already won this matter in Honorable Tribunal Delhi Bench of ITAT. Against that, department has filed an appeal before Honorable Delhi High Court. Now, what was the contention of the revenue before the Honorable Court? The contention taken by the revenue before the Honorable Court was, circular only applies to the communications emanating from revenue and not vis-a-vis the substantive order passed qua the assessee. Number two, failure to generate and allocate DIN in this case is a mistake or at best a defect and or an omission which ought not to invalidate the reassessment proceeding, assessment proceeding. And they have relied on a judgment of Jagat Novel Executive Private Limited. The contention of the respondent, which is Brandex Mauritius in this case, was the 2019 circular is binding on the revenue. It is binding on the revenue. Number two, the error is jurisdictional in nature and therefore cannot be corrected by taking recourse to section 292B of that. 292 very clear say, though in spite of that you have participated in the proceeding, that doesn't mean that jurisdictional, because you being participated never raised this question at that level, that doesn't mean that your jurisdiction nature is changed. It is an error in jurisdiction in nature. So I can take this jurisdictional point at any level. And they have, the respondent also have relied on three very important judgments wherein it categorically says that circular is binding on the revenue. Department was taking the contention that this is not binding on us. We have taken a position that the circular is binding on the revenue. One was UCO Bank versus CIT, which was reported in 237 ITR 889, pronounced by Honorable Supreme Court. Another judgment was Ellerman Lines Limited versus CIT, a very old judgment of 1971, reported in 182 ITR 913, pronounced by Honorable Supreme Court. And third is DCIT versus Sunita Finleys Limited, 330 ITR 491. We relied on three judgments which talks about circular is binding on the revenue. Now, another contention which department have taken, we have countered that thing and we have taken a position that recourse cannot be taken to the provisions of section 292B of the Act. And based on that, we have relied on two important judgments. One, Principal CIT versus Maruti Suzuki, 397 ITR 681, Honorable Delhi High Court judgment. And another, we have relied on an Honorable Supreme Court decision in the case of CIT versus Spice Infotainment Limited, 12 ITR OL 134. So, friends, it is clear what was the contention of the revenue. circular, not applicable, failure, jurisdictional issue. We have countered by giving a contention that it is binding, relied on 3 judgments. And number 2, 292B of the Act cannot be taken, records cannot be taken, relying on 2 judgments. Interestingly, in this case, Honorable Delhi High Court, after analyzing the circular in detail, seeing all the clauses of the circular, after considering the contention, after checking the judgment they have relied, after considering the contention of the respondent, which is Brandeis Mauritius, seeing the judgments, they have decided that the assessment order passed without quoting DIN was invalid / non-est in accordance with the binding circular issued by the CBDT. So what they have seen that certain shelters are there for the department in the circular, but for going and taking the benefit of those clauses, exceptional circumstances, you need to comply with certain procedures which has not been complied, way which has not been complied by you. That is the reason they have said that this particular is non-invalid. And in this case, friends, there was nothing talked about the merit. That Honorable Tribunal Delhi bench has completely relied on this particular legal argument and have, based on that, they have allowed the appeal of the assessee, Brandeis Mauritius. Honorable High Court relied on a famous case of KP Varghese versus ITO, 131 ITR 597, for the principle that circular issued by the CBDT in exercise of its power under section 119 of the Act are binding on the revenue. And it was also held that the act of non-obtaining DIN is a jurisdictional defect which cannot be considered a trivial mistake condonable under section 292B of that. So Honorable Delhi High Court, after seeing the judgments circular, considering the contention of both the sides, have discussed that based on the Honorable Supreme Court decision, the CBDT has, whatever the circular issued by CBDT are binding on the revenue. Number 1, they have accepted a contention. Number 2, they have also accepted a contention that the act of non-obtaining DIN is a jurisdictional defect, irrespective whether you have participated in the proceeding. But in spite of that, you can take the position because this is a jurisdictional defect. These were the findings given by Honorable Delhi High Court in the case of Brandeis Mauritius, pronounced on 13th or 14th of October. 14th of April 2023. These are the judgments, friends, which was relied in this case: Back Office IT Solutions, CIT versus Jagat Novel Exhibitors, CIT versus Maruti Suzuki, CIT versus Spice Infotainment Limited, CIT versus Sunita Finleys Limited. Why this judgment is relevant, friends? Because this is first Honorable High Court decision in India wherein the position has been taken about the validity of a DIN. First judgment pan-India. Now comes the next, the Delhi Tribunal. In this case, the court dealt with a question regarding the validity of the assessment order issued without quoting DIN in it and issuing a DIN through a separate communication after a period of 15 working days. You remember, friends, we have discussed when you are taking a shelter under the exceptional circumstances, you need to comply with the procedures. Once you comply with the procedures, there is a process called regularization which you need to comply, wherein a 15 working days time slot is given. You need to comply within that. In this case, it was regularized after 15 days. Now, friends, Honorable ITAT relied on Honorable Delhi High Court in the case of Brandeis and held as under. So they have relied on the decision of Honorable Delhi High Court. A perusal of the impugned assessment order makes it clear that in the body of the assessment order, the assessing officer has neither recorded the reasons for issuing the assessment order manually. Now, what was the procedure which we discussed, friends? It is manual reasons. So what they have observed that in the body of the assessment order, the assessing officer has neither recorded the reason for issuing the assessment order manually without DIN. Number 1, first procedure they have not complied, which is a mandatory condition, nor the date and number of approval of the Chief Commissioner or Director General of Income Tax. That means they have not complied, though they have taken the shelter of exceptional circumstances, but they have not complied with the procedure, which is mandatory. So procedure was lax, so you cannot If they are not complying with the procedure, you cannot take the benefit of the exceptional circumstances. The subsequent communication dated 3rd February 2022 issued by the of the assessment order cannot make good efficiency in the assessment order issued without generating DIN. Now, what happened in this case? Subsequently, they issued a communication wherein they generated DIN. So, can a subsequent issue of notice can make a good an order which was issued without a DIN? No, it cannot. As the assessing officers failed to adhere to the conditions of paragraph number 3 of the extant circular, which is a procedure wherein it has been specifically mandated that in a case wherein the assessing officer has to issue the communication manually without generating DIN with the prior approval of the CCIT/DGIT, not only he has to record the reason for doing so in the file, but he has also to incorporate in the body of such communication the reasons and the number and date of approval by the CCIT or
Hi, sir. Are you facing any issues?
Hi. Hi, Pranjal. Am I audible?
Yes, sir. You're audible now.
So have we discussed? Have I discussed this slide? Is everybody my voice is audible to everybody? Yes, friends. I hope I am audible. I have discussed this Pratap Singh Yadav decision with everybody. Next decision was Honorable ITAT Bangalore bench. Friends, we have discussed Honorable Delhi High Court decision in the case of Brandex Mauritius Limited, pronounced in April 2023. After that, we have discussed about this decision of Honorable ITAT New Delhi bench in the case of Pratap Singh Yadav. Third, very important decision, which is in the case of Honorable ITAT Bangalore bench, Dilip Kothari. Honorable Bangalore ITAT, in this case, dealt with the question of whether an intimation of DIN issued through a separate letter along with a manual order under section 263 without DIN is valid or not. So I'm again going into the flashback. Friends, we have discussed about circular. We have discussed about exceptional circumstances. We have discussed about in case if the department is taking the shelter under exceptional circumstances, they are supposed to follow certain procedures. If the procedures has not been followed, that is the notice become non-est. If they had followed the procedure, you need to see whether they have regularized it properly or not. So now, friends, in Dilip Kothari, what is an issue is they have issued an intimation of DIN through a separate letter, but the order was issued manually. So instead of issuing 263 order with a DIN, 263 order manually and a separate letter issued wherein the DIN number is coming. So is it valid or not? Whether such intimation, now the moot question which is coming in this order is whether such intimation can be considered to be a part of the order or not. Now, in this case, assessee challenged the validity of the order, stating that the DIN must be quoted on the body of the order and not through a separate intimation. This was a question of law framed before Honorable Tribunal. Now, let us now the ground we have taken before the tribunal. Now, let us see what was the finding of the tribunal in this case. In assessee case, there is no dispute about the fact that the impugn order under section 263 of the Act has been issued manually. So there is no dispute that the 263 order has been issued manually. It is also noticed that the DIN for the order is generated through two separate intimations. One bearing the same date as the date of the order under section 263. Another is dated 25th March 2022. So what happened in this case? After issuing a manual order 263, they have issued two separate intimation wherein a DIN number is coming, one of the same date when they have issued manual order, another of the different date. which is 25th March 2022. So in this case, the revenue contention was that the intimation dated 24th March is part of the order. That means a separate intimation on the same date issued. You please read it as part of the 263 order. And there is no violation, and it cannot be accepted as generating the DIN by separate intimation as allowed to be done to regularize the manual order, provided the manual order is issued in accordance with the procedure as contained in para 3. So when the Honorable Tribunal has seen the order, what was the finding which is coming is, on perusal of the order under section 263, it is noted that the order neither contains the DIN in the body of the order. Number one, DIN is not there, nor contains a fact in the specific format. What was the format which we have discussed, friend? Exceptional criteria. It was not discussed. Under exceptional criteria, you need to follow the procedure. They have not followed the procedure. No reason mentioned, no approval mentioned, nothing. And therefore, we are of the considered view that the impugn order is not in conformity with para 2 and para 3 of the CBDT circular. So after these observations by the Honorable Tribunal, after considering the contention of both the sides, they have decided that this impugn order is not in conformity, and hence they have allowed the appeal of the assessee. Now, important thing which comes here is recently, friends, on 18th July 2023. Now, these are the decisions, the Delhi High Court, the Delhi bench of ITAT, the Bangalore bench of ITAT. These are the decisions in favor of assessee. Now, we have a judgment of Honorable Allahabad High Court, recent judgment in the matter of Chandrabhan. The writ tax number was 829 of 2023. This was pronounced on 18th July 2023, recently, around a month back, 1.5 months back. This is against the assessee, or I must say in favor of the assessee, in favor of department. Now, but in this case, what was the catch point, friends? Honorable Delhi High Court Brandix was 260A appeal, ITA number, following appellate jurisdiction. To ITAT decision was appellate jurisdiction. This was a case wherein the petitioner, the assessee, has invoked the writ jurisdiction under Article 226. They have filed a writ petition before the Honorable Allahabad High Court. Honorable Allahabad High Court in this matter, interestingly, now has one of the judgment in their favor, which they can take it at any way. Allahabad High Court dismisses assessee's writ petition challenging the reassessment order on the ground that the notice under section 148 was issued manually without the DIN. Honorable Allahabad High Court notes assessee's argument that the notice issued without DIN is in violation of CBDT circular, which mandates that all departmental communication must bear a unique DIN. Now, friend, what happened in this case? In this case, the assessee has challenged an order. Assessee has not challenged a notice 148. They have challenged an. So as soon as you have an order, and when you challenge in a writ jurisdiction, you are supposed to inform the court. The court is aware that you have an alternative remedy available. Alternative remedy means you can file an appeal before CIT appeal or a DRP in case if you are an eligible assessee. So this was the case wherein the department has taken the pleading that yes, this is a case wherein they have an alternative remedy and they can go and file an appeal before the CIT appeal instead of coming in a writ jurisdiction. Honorable High Court accepts the revenue argument that the assessee participated in the proceedings, same 292B, which was in the case of Brandix, it was categorically mentioned that in spite of that you being participated, because there is a jurisdictional issue involved, you cannot, the 292B cannot put a barrier on them. You cannot take the pleading and take the shelter under 292B department. But in this case, what happened? Honorable Allahabad High Court accepts revenue argument that the assessee participated in the proceedings and the reassessment order was passed only after consideration of his reply, and rejects assessee's argument that the reassessment order is without jurisdiction since notice were not issued on DIN, by observing that no prejudice is shown to have been caused to the assessee by issuance of manual notices. Something very different finding. And it observes that the assessee acknowledged receipt of such notice and has also submitted the objection which have been duly adverted to. What they observe that you have received the notice, you filed an objection, and that has been handled at the time of assessment. So the Honorable Allahabad High Court has taken a position that non-issuance of notice on DIN would thus not be a ground to entertain the writ petition, notwithstanding the availability of alternative remedy. So they have taken a position because the notice was issued without a DIN, cannot be a ground to entertain the writ petition. Now, friends, very important. This is the position which they have taken. I would suggest let us see what does Honorable Allahabad High Court talks about. Let us see the judgment first of all. This is an against decision of the, this is in against assessee and in favor of department. Let us see this judgment again and see where the Lucano, the gap is coming. The petition is directed against the order of reassessment passed against the petitioner. A preliminary objection is taken to maintainability of the writ petition on the ground that petitioner has remedy of filing statutory appeal where all questions of facts and law can be adjudicated. Okay, so they have observed that they have an alternative remedy available. Learned counsel for the petitioner, which is the assessee, states that proper opportunity was not given. Why they have taken this position? Because you cannot file a writ. Either jurisdiction or violation of principle of natural justice, only you can take it after you file a writ in case after passing of an order. And that the notice under section 148 of the Act was issued manually instead of it being issued by applying the DIN number. Such notice is said to be in violation of the circular issued by the department. Department contention was petitioner has participated in the proceeding 292B and only after consideration of his reply the reassessment proceeding have been concluded. So they have taken the shelter of 292B by saying that they have participated in the proceeding and their query has already been addressed there. So there is no question of coming in a writ jurisdiction before the Honorable High Court. In the fact of the present case, we are not inclined to entertain the writ petition in view of the availability of statutory alternative remedy. First, very important reason of dismissal or writ petition was alternative remedy. What the court was saying, if you already have an alternative remedy of filing an appeal against the order, there is no reason of coming in a high court. Now, second point which they have addressed, the main argument is that orders is without jurisdiction since notices were not issued on DIN. Now, why this important? Because in a writ jurisdiction, jurisdiction is very important issue. That is the reason they have addressed this jurisdiction issue, not issued on DIN. This argument is noticed only to be rejected since no prejudice is shown to have been caused to the petitioner on account of issuance of manual notices. No prejudice. There is nothing called when the position taken by the High Court was that no prejudice is shown to have been caused to the petitioner on account of issuance of manual notice. Totally against the circular. Admittedly, the petitioner has acknowledged receipt of such notice and has also submitted his objection, which have been duly adverted to. Non-issuance of notice on DIN would thus not be a ground to entertain the writ petition. Now, friends, what is very important you see, in this judgment, it seems, I don't know what happened at the time of argument. In this judgment, there is nothing mentioned about circular, no circular referred, no paras of the circular referred. This was pronounced in July 2023. I think Brandix decision was not taken before the Honorable Court. That they look, my lord, this Brandix judgment of the Honorable Delhi High Court is there. This was not quoted. It seems so. I'm not sure whether they have quoted or not, but it seems so from the order that this particular judgment was not quoted. No particular judgment was quoted which is supporting the DIN documentation. That is a reason, one of the reasons that the Honorable Allahabad High Court has issued this order. So what I will say, anyway, the jurisdiction of Honorable Allahabad High Court can always take this judgment as a precedent judgment. But yes, you can always distinguish this judgment by coming out with certain facts in your case. Now, friends, this is all about this thing. Let us now, we have already discussed, let us now see what does this circular talks about. We have already covered in this judgment in our slide, but let us see this circular also once to understand it properly. This is the circular number 19/2019, dated 14th August 2019. The title is Generation, Allotment, Quoting of Document Identification Number in Notices, Orders, Summon, Letter, Correspondence issued by Income Tax Department. Now we are talking about paras. These were the paras, friends. Let us see what are the paras. I'm coming directly to para number 2. Let us see para number 1 first of all. 1, 2, 3, 4, 5th. I'm reading from 5th line. However, it has been brought to the notice of the Central Board of Direct Taxes that there have been some instances in which the notice, order, summon, letter, and any correspondence were found to have been issued manually without maintaining a proper audit trail of such communication. So this was brought in the knowledge of the Government of India, Department of Revenue. So this was one of the reasons of issuing this circular. Para number 2 says, in order to prevent such instances and to maintain a proper audit trail of all communication, the board, in exercise of power under section 119 of the Act, has decided that no communication shall be issued by any income tax authority relating to assessments, appeals, order, statutory or otherwise, exemption, inquiry, investigation. Every word is important, friends. Verification of information, penalty, prosecution, rectification, approval, etc. to the SC or any other or after 1st day of October 2019. This I have discussed in my first slide. Unless a computer-generated document identification number has been allotted and is duly quoted in the body of such communication. This I have discussed in the first slide, on or after 1st October 2019. Now we have continuously, I'm talking about a shelter which the department can take. What were the exceptional circumstances? Para 3 talks about, friends, exceptional circumstances. I'm not reading because I've already discussed in a slide. Now, para 3, please see last para. This is the procedure which we are. What are the procedures? This is about the procedure. The communication may be issued, please see last para. The communication may be issued manually, but only after recording reasons in writing in the file and with proper prior written approval of the Chief Commissioner or Director General of Income Tax. In case where manual communication is required to be issued due to delay in PAN migration, the proposal seeking approval for issuance of manual communication shall include the reason for delay in PAN migration. Reason is very important. Sanction is very important. The communication issued under aforesaid circumstances shall state the fact that the communication is issued manually without a DIN and the date of obtaining the written approval of Chief Commissioner or Director General for issuance of manual communication in the following format. Friends, this is the format. This is the line which is important. It is equally important to have these lines in your order in case if it has been issued manually. This communication issues manually without a DIN on account of reasons given in. Now, these are the limbs, para 1, 3. In case if the department is saying they fall into para 3, clause 2, then they only mention para 3, clause 2. This line is important. If this is missing, then the catch is there. Then you have a full right to challenge this particular notice. Any communication which is not in conformity with para 2 and 3 above shall be treated as invalid. Now, this was the analysis of the Honorable Delhi High Court in the Brandex. They have seen para 2, they have seen para 3, they have seen, then they have followed para 4, then they have seen para 5. After seeing all the paras of the circular, they have taken the position and they have pronounced a decision in the case of Brandex. So I just thought to show this particular circular also to you. This is all about our slides on significance of document identification number income tax department communication. Very small thing, very important. Now, many of the decisions of Honorable Tribunal is coming pan-India after Brandex decision. Friends, definitely whenever you receive any correspondence, be it 148 clause B notice, D order, 148 notice, anything, please definitely go through the circular, see whether everything is complied or not. And in case if it is not, then you can take a position in your ground and you can also give a thought whether you wanted to challenge it in a writ jurisdiction or not at the appropriate time. Now, any questions, anybody? Pranjal, over to you. If anybody has any question, I would love to address those questions.
Hi everyone. In case if you have any questions, you can shoot your questions to Devanshu sir and sir will answer accordingly.
Or anybody, I'm not sure, Pranjal, maybe I was on mute for some few seconds or minute. In case if I miss some slide or somebody has missed some slide wherein, so you can discuss it right now with me.
Sure, sure. So there is a message from one of the participants. If you can repeat the last 2 minutes.
I can repeat the last 2 minutes. So they wanted
Yes.
me to repeat the slides, or they wanted me to repeat the circular. I have shown the Allahabad High Court decision also. I have shown the circular also. They wanted me to repeat last two tail of the slides presentation, or
So there is a question also of Ashish in the chat box.
if the assessment order is received with DIN. If the assessment order is received with DIN, but without there being digital signature of the person signing the order, whether the assessment order is valid. Without digital signature, consider, but the question is whether it was issued by JAO or FAO. It was issued by a jurisdictional assessing officer or faceless assessment officer. Anyway, digital signature is mandatory. So if they have issued without digital signature, then yes, you can challenge it. You can think of invoking a writ jurisdiction and can file a writ petition also. If you don't want to go with that, you can take this position, this particular ground in your appeal also, first appeal also. Ideally, technically, this is incorrect. As per Information Technology Act, every order they are supposed to put it in a digital signature. The date, time of the digital signature must come in the order. JAO, jurisdictional assessing officer, same thing. It is mandatory to have a digital signature. If it is not there, but you need to see whether in the earlier correspondences, all the notices they have issued under 143.2 or 148 or 142.1, whether they have issued with a digital signature or not. In case if they have not issued order if they have issued order without digital signature, then you can challenge this particular point. You can take this ground. Date and time of signing is not coming out from the assessment order. Anyway, if the digital signature is not coming, then obviously date and time will not come. Date and time will only come when there is a digital signature.
Hi
Anybody
everyone.
else? Any other question?
Any further questions from the Devanshu sir? So I think we can close today's session then.
Sure, Pranjal.
Sure. Thank you so much, sir, for today's insightful session. And it was a true delight to have you with us today.
Thank you so much, Pranjal. Thank you, Arun. Thank you, Team Educating. Thank you so much.
Okay.
And thank you
so
all the
much,
members for
everyone.
the patient listening.
Thank you, sir. Thank you so much, everyone. Good night. Bye.
Thank you.